Perfect. Okay, Hans, good morning, good evening.
Hi, good morning.
I hope we can hear and see me well. We hear and see you perfectly.
Yeah,
So-
fine too.
Yeah, the class is ready for your Lectio Magistralis, and then after this we have a debate on this. I make you see the room, which is very nice, hoping that one of these days you can come with us.
Oh, that's really beautiful.
Yes, yes, yes. We hope we will be together in person the next time. And so now we are ready to hear your lesson, and also, if you like, to share with you the presentation. If you have a PowerPoint presentation to share, I think now you are enabled as keynote speed, and so you can, if you like, make it upload it. And so I give you the floor because I just two things I want to. I did anticipate this, and I want to thank you again because I have anticipated that your lesson is extremely interesting, and so they are ready to listen to it and also to have a little debate at the end. So now I give you the floor, and I thank you very much again.
Thank you so much also for the invitation. I'm trying to share my screen now.
Perfect.
That's great. So, but now I can't see you. So if you have any question within the lecture, just ask something because I'm not able to see anything anymore.
Yes, in case I will ask you something, but we try to listen everything and to do a question time at the end of the lesson. So in any case, if something come up, I will tell you that we are ready for a question.
Okay, great. So thank you very much for being here today and for the invitation. And I'm happy to talk about the future of mobility with a focus on the relevance of technology regulation and technology design. First of all, some sentences about myself. I'm a lecturer at the University of Stuttgart at the Institute of Economics and Law at the Department of Law. And there I'm teaching courses on autonomous driving with legal aspects and on legal aspects of AI. Furthermore, in my main job, I'm working at the data protection at Carriot SE. It's a Volkswagen Group company, which is developing all the intelligent functions you have in your car, beginning from a navigation system, ending up with an driving assistance function, an automated driving function. I'm editing a lot about the autonomous driving. That's why I'm like a member of the round table of autonomous driving set up by the German Federal Ministry of Transport. And I'm really interested in all digital themes like AI. I edited something about the metaverse. And the last days, a book in the Springer Nature was published about liability on autonomous vehicles. So this is like my main topic of interest, or digital themes and in connection with liability or regulation aspects. When speaking of the future of mobility, there are some levels of automated driving which are being distinguished. The most famous one is the international classification from the SAE J3016. And then there are some national standards, like for Germany, the VDA and the BUST. And then there had been this NHTSA definition in the US, but nowadays they just recommend to use the SAE definition, so the NHTSA definition isn't active anymore. And when speaking about these levels of automated driving, on the very left, you have the 0. There you can imagine an old Fiat Cinquecento, where you are driving all by yourself. Like you have to perform all driving tasks by yourself. There's no system which is intervening with you, and you have to monitor the drive. So you're the driver and you have to take care of everything. And then with level 1 and 2, you have some driving assistance systems which are being there for comfort reasons or for safety reasons. And the system there can take either the steering or acceleration or the deceleration, but the driver must continuously carry out the other one, and the driver has to monitor the system. You know, perhaps from some cars, you have to hold your hand on the wheel, and if you move them away, it will make a sound and tell you to take back the full control of the vehicle. And then it begins to be interesting with level 3, where the system takes over both steering and acceleration in a defined use case. It's called the ODD, the operational driver domain. And there it's capable of recognizing its limit, and it's notifying the driver. And the driver doesn't need to monitor the system while the whole drive, but he has to be aware if the system calls him back, because he is like the fallback system for the technical system. So if anything occurs or the system reaches its limit, then the driver has to take control and drive the car. And that differs to level 4, where the driver can hand over the entire driving task to the system in a defined use case. And there the driver isn't required at all, neither as a fallback, nor to take any actions, and the defined use case. And that's why it's very interesting for companies like Volkswagen, Mercedes, and so many other, could be an entire city. So if you say your defined use case is a city, you don't need a driver anymore if you're just operating this car in a city. So for some scenarios, this can be very interesting from an economic point of view. And then the most future kind level of automation is level 5, where the system can take over the driving task in all use cases. So it can be driven in the city, on the autoroute, you can drive it everywhere and no driver is required. So it's like anytime and everywhere where the system is capable of doing the driving tasks. And speaking about the automation of motor vehicles, there are a lot of opportunities which can be realized. So one thing is that increasing road safety and efficiency is one main topic, and the reduction of emissions. Then there's an increasing participation in mobility for young and older people as well as for people with physical restrictions. And in addition, there's a better connection of the countryside and suburbs possible, because nowadays there are some regions in Germany, for example, where there are no buses or cabs, and people have to own their own car in order to go to the city or to be able to shop something. And so this would be a real benefit for them. So there are some different business models when speaking of autonomous and automated driving. First of all, you can think about so-called teleoperated driving. With regard to this, in Germany, there are no legal regulations on teleoperated driving. So there's neither a specific law, nor have the Road Traffic Act and road traffic regulations been supplemented with any behavioral requirements. And operators of teleoperated vehicles therefore face numerous questions, starting with requirements for the registration of the vehicles and ending up with their operation or requirements for the cybersecurity, because they have to have like a 5G connection. So there are a lot of really interesting questions coming up when you're deploying a teleoperated driving system. And in the event of an accident, there's also no special liability regulations which apply, but instead the traditional liability regulations apply. So in Germany, these are the driver liability, the owner liability, and the liability of the car manufacturer or of the manufacturer of the teleoperated system when he becomes like the manufacturer. The driver liability, so won't be applicable because there are only passengers in the vehicle, speaking of teleoperated driving. So this can't be applied to the scenarios. But you can think of the person controlling the car remotely of being the driver of this car, because this person executes the longitudinal and lateral acceleration. So it basically controls the vehicle remote, not in the car. So, however, unlike conventional drivers, you have to think about if it's a problem if the driver isn't in the car, but this could be applied by analogy, so there is no liability gap. And the owner's liability is designed in Germany as a strict liability and applies at all time. Therefore, it's not interesting whether a human or an automated or autonomous driving function is controlling the vehicle, or if the driver is in the vehicle or is controlling the vehicle remotely. So in practice, this liability is perfect for injured parties, as the owner is like the simplest liability addressee, because in praxis, you're just going to sue the owner of a car, and he's in a good position because you won't have to pay the amount directly because you have like several insurances, and they have to pay in the event of an accident. So you sue the owner and his insurance company, and they will pay for the injuries and all damages. So this is the easiest thing in Germany to have. And then you have the producer liability, which bases on the one hand side on the Product Liability Act, which was enacted to harmonize product liability in the whole European Union. And on the other hand, you have a very detailed case law, which was developed and called the producer liability at a very early stage, like in the 1918 or 1915, something about that. There were the first court decisions concerning the so-called producer liability. And that's not specifically regulated, but is derived from paragraph 823, which is like our general tort law regime, and it's based on the violation of so-called Verkehrspflichten, like care of duty. And these are safety duties based on negligence. So you ask yourself in front of a court if there's any duty you have violated, and if so, if damage is resulting from that, then you can get like costs or something like that. And as I said, the keeper's liability is supplemented by compulsory insurances. So in the external relationship, this insurance company settles the damages, and that's a very big advantage for the injured party. And it's very easy to get compensation for all damages. So you don't have to sue the driver, you don't have to sue the owner, you don't have to sue the manufacturer. You can at first, if you're the injured party, go and sue the insurance company from the owner or the keeper. So with regard to teleoperated driving, there's no liability gap in Germany because injured parties have at least the keeper's liability and the producer liability. If you're arguing that the driver liability isn't applicable because a driver has to be in the car and it's not enough to have a driver which is controlling the vehicle fully remotely. And then there are like other areas of application for autonomous driving, like moving people, and it's called mobility as a service. And that's a perfect use case for the level 4 systems I showed you early, because there you can say the operational driving domain is inside a city, and there are these moving and mobility or moving people cars just work like normal buses and can pick up people, and there you don't need a driver at all if you're operating it in the city and if the city is your operational design domain. Then you have like services to transport services or goods as a service, like this car from Neuro bringing something people bought. Then you have this so-called automated valet parking, where your car is parking in a garage on its own. And then you have like private ownership cars, where you have a normal car like in Fiat or something else, like a Volkswagen, and you can enter the automated autonomous mode and switch control with the system. Other areas of application are far more advanced nowadays, like platooning for hub-to-hub cases. That's very important for trucks and for moving goods on the outer route. And then what's really developed nowadays is like self-steering harvest trucks, because there's no traffic on the plant and you can deploy all these cars very easily because they do not fall under any regulations for driving on a normal street. So that's a very, very simple case where the harvest truck just follows a route and is doing things there. Speaking of autonomous driving, there are really many aspects, and it starts for companies and society through new business models, which bring along economic impacts. There are a lot of social impacts, which range from the design of cities to our everyday life and habitus. And you can think of a shift from private use and owned vehicles to something you could call a shared economy, where one don't own a car, but use it with many other people together. And when you think of the car today, the private motor vehicle has a very high value and a very high social status in Germany, for example. It's partly an expression and enabler of individual mobility, and it's really like a status symbol. And there you have to think about new behavior. And in Germany, legal scholars have discussed whether there's a separate fundamental right to mobility that can be derived from the Constitution. So mobility is a very important thing in Germany and many other countries. And legal issues are increasing due to digitalization and the automation of motor vehicles, thinking about accidents, thinking about liability, negligence, and many other topics. And due to that, Germany has twice in 2017 and 2021 amended the Road Traffic Act to enable so-called highly and fully automated driving. And thus, there's a legal framework which exists for the operation of these vehicles. But the liability law has not been changed. And yesterday you could read in the German newspapers that the Ministry for Transportation is working on a draft for regulation concerning teleoperated driving. So even this is something they want to address now in a law. Thinking about the automation of vehicles, data processing is increasing. You have to use several sensors like LiDAR. You have to use camera sensors to see the environment of a car. You have a radar, you have ultrasonic sensors, you're using highly detailed maps from the city, which contain all the streets and everything you have to know. And that's going to tackle a lot of data-related things like the GDPR, speaking about personal data, and the question if the General Data Protection Regulation is applicable, if you have data privacy principles, and if you have fulfilled them as a manufacturer. You can think about data ownership, like who's the owner of the data being created in the car, of the environment, or the data from the passengers in the car. And also deep learning and AI, other algorithms need a huge amount of data to be developed so that there's an automated driving function which is able to detect objects. So it's all about data to develop these automated and autonomous driving functions. Speaking about data and like AI, you have to ask what's the impact of the new European AI draft regulation on the future of mobility. When you think what happened so far in 2018, the European Commission published its AI strategy, focusing on some topics like trust, like liability. And in 2020, the Commission published its so-called white paper on AI, where they had really concrete plans to regulate this new technology. Just 1 year later, in 2021, the Commission published a draft regulation for the regulation of AI, which was then heavily debated in the last 3 years in the whole European Union, and a lot of companies took action and spoke to people from the parliament, took or participated in public consultations. And now in 2024, the EU Parliament voted for the AI Act in April, so last month. And at the end of this month, the Council of the European Union will give their final okay. So it's said that they won't interfere with this act because it's like very prestigious project for the Commission. So this year the AI Act will be there. What are the goals of the European Commission when thinking about the AI Act and regulating AI? They're having in mind to have a functioning internal market inside the whole European Union, and they want to protect fundamental rights, especially dealing with health, safety, and other fundamental rights like discriminating people. They want to avoid that, or data protection rights. Then they want to prevent single member states of setting up restrictions concerning AI. And they want to have a harmonized legal framework, which is being harmonized within the whole European Union on the level of a regulation and not on an act. They want to enhance the development and the use and broadening of AI, and the European Union wants to claim a global leadership when it comes to AI, and therefore they want to have the first fully harmonized legal framework in the world. So what comes to your mind when speaking about AI? Nowadays, you would answer probably like ChatGPT or something like this, but a lot of manufacturers are going to advertise normal products they produce with AI. So ORB says the revolutionary Genius X with AI inside the toothbrush. Some manufacturers of cameras are saying never miss the perfect shot with AI to have a perfect autofocus or to stabilize the picture and something like this. So there are a lot of products being advertised with AI. And when you think of regulating AI, you have to think about the basic functions of law. Law is like an enabling function, and there's a regulatory function of law in general. The enabling function of law can be derived, at least in Germany, from the general freedom of action of the German Constitution, where it says every person shall have the right to free development of his personality insofar as he does not violate the rights of others or offend against the constitutional order or the moral law. Then you have another article, Article 5, in the Constitution, which says art, sciences, research, and teaching shall be free. And even in the Fundamental Rights Charter of the European Union, in Article 13, it says art and research are free. Academic freedom shall be respected. So these rights guarantee the development of new technologies, which include AI and autonomous driving. So law is there to enable these development and new innovations. And then you have something like a regulatory function of law. There you can differ between an active and a passive regulation with direct or indirect effect. An active regulation is carried out, for example, by the Product Safety Act or the German Road Traffic Act or the forthcoming AI Act, where you have clear requirements towards a product and the development of a product. An example of passive regulation is German tort law with product and producer liability, because they have an indirect effect on the manufacturer's design, fabrication, and quality control, as well as on the instruction, because if there's a defect of the product, they have to pay if they are getting sued. So they are having to have a really good fabrication and quality control to avoid these costs. Another part is something called technology design. And speaking about the design of technology of automated vehicles or AI, there you can find people pessimistically saying that the design of a technology by the society is not possible because they argue that the development of technology follows an inherent dynamic of technology, which is called in the social sciences and in philosophy something like technological determinism. However, this assumption is outdated and underestimates the power of law as well as the two-way interference between technology and society. Technology design deals with the design of technology and the two-way interference of society and technology. And technology regulation, on the other hand, pursues the goal of minimizing the risks of a technology and creating a consistent level of safety through binding requirements. And law has a direct effect on the technology design, so that all influences of law on technology are included. But technology design also has an effect on law and on the reality of society. So they are really like a two-way interference between society, law, and technology. Therefore, a separation of technology regulation and design in the sense of a dichotomous view is not possible because they are influencing each other. Technology design, when we think about the design of a product, it's originally in the sphere of the manufacturer. He can design and he can decide how the product will look like, what functions the product has. And technology regulation, on the other hand, is carried out by the state. There's one exception, which is the self-regulation in private law. For example, speaking about technical norms and standards like these so-called ISO standards, which aren't law by a state, but in fact self-regulation in private law. And the manufacturer's decision in designing the technology can be limited. If binding legal sources or legal principles have an influence on the design of a product, then the manufacturer has to obey these requirements. There's also a huge impact of law, speaking about technology design. And first of all, you have, when thinking about AI, some requirements coming from the fundamental rights. So there's an indirect third-party effect of private parties through Article 3 of the German Constitution in case of the exploitation of a monopoly structure or a structural superiority in order to exclude persons from anticipation in social life without objective reasons. Private parties may also be bound by fundamental rights in the case of other fundamental rights, in the case of an accumulation of enormous social power, which endangers the freedom of other person, which itself leads to a limitation by the affected fundamental rights of others. Thinking about autonomous driving, in addition to the requirements of the German Road Traffic Act, you have to think of, when you're programming the car, about the third-party effect of human dignity in so-called dilemma situations. So you can't design the car as you wish to behave in these situations. Speaking about regulation of a technology like autonomous vehicles or AI, you're speaking about risks of new technologies, and you have to ask yourself if risks are increasing or if it's just the communication about risks. According to Luhmann, which is very famous in Germany from social sciences, he said that danger and risks have in common that there's uncertainty with regard to future and damage. If a damage results from a decision, it is said to be a risk. And if the damage results from an external influence, then there shall be a danger. But this definition hasn't played any important role in the social logic of risks, because it's not really possible to make a clear distinction between decisions and external influences. But risk is neither a damage nor a concrete threat, but it's the product of the degree of damage and the probability of occurring. So it's therefore very difficult to approach and evaluate slow-moving risks if the probability of occurrence tends towards zero on the one hand, but the severity of a damage is extremely high. The acceptability of a technology in the society is very low. You can think, therefore, of nuclear power plants, and in Germany there was a huge debate in the 1970s and 80s if these are too dangerous to be deployed in Germany. And in the context of autonomous driving, the so-called dilemma situation is a much discussed risk in the society and in news, with a considerable degree of damage, and at the same time a very low probability of occurrence. So there's the same problem because it's a slow-moving risk. If the legislator thinks that there's a risk, we have to think about the regulation of these risks. But regulation of new technologies like AI poses great challenges for the legislator, because the initial regulation sets the course for the further development and use of the technology. there is, you can say, the danger that once a regulation has been made, it can no longer be changed. So it determines the allocation of costs and benefits for developers and users of this technology. First of all, you have to ask yourself as a legislator if a regulation is really necessary or not. And you have to take into account if private standards like ISO standards are sufficient, or if there are no private standards, and therefore you have to have a regulation. And if there are private standards like the ISO regulation, but no law, you have a problem occurring in self-regulation, because this poses a problem that can be illustrated by the game theory. Without the state as a regulating and sanctioning third party, for example, there's often no optimal situation with regard to product safety. If the market controls itself completely, there's a commitment problem in addition to the collective good problem. It's called tragedy of the commons. And this results in a non-Pareto optimal Nash equilibrium. And consequently, the actors have no incentive to diverge from their previous behavior. In fact, they could have a loss of income, so there's no incentive for them to optimize like the product safety. This differs if you have a binding regulation which forces every manufacturer in this kind of field to take action and to improve product safety. And on the other hand, the loss of income, for example, would be the same for every manufacturer. If the legislator thought he needs a regulation for regulating risks, you have to ask yourself of how to regulate these risks. Because speaking about AI, for example, risks of new technologies are not sufficiently investigated and known. This applies equally to empirics and epistemology. The regulation, on the one hand, is very effective for a new technology because there's no existing law, and the technology is very new and can be influenced very effectively. However, the risks are not certain. You don't know every risk which could occur and when. In the case of a traditional technology, on the other hand, the risks are well known, because after like 20 or 30 years, you know the risks coming up with a certain product, but it's then very difficult to regulate the technology or product. And this difficulty is called the so-called Collingwood dilemma, which is a challenge that parliamentary technology impact assessment faces when they have to decide what's the impact of a new technology for the society and what risks come up. The contingency makes it very difficult to predict risks. That means nothing less than the phenomenon of ambiguity and multiple paths of the future. So you don't know what will happen when and how a technology will move on. Speaking about the upcoming AI Act, let's have a look at the scope of application. Concerning the territorial scope and personal scope of application, you have to know that it's a horizontal, like a cross-sectoral regulation, which isn't applying in one field, but is covering all sectors AI is being used. There's an exemption of some sectors from the scope of application. And there you have like the territorial scope, and that said that providers of an AI system are the ones placing the AI system on the market or putting it into service in the EU, so it's very broad. And if there's an independent of place of establishment, and deployer have to be inside the European Union to be affected from the AI Act. And provider and deployer can be in a third country as well if the AI system is being used in the European Union. Coming to the personal scope of application, provider is the person which is developing the AI system under its own name and brand, and for a fee or free of charge, and placing this AI system on the market or putting it into operation, and the deployer is the person which is using the AI system on its own responsibility. And there's an exception which is nearly the same as inside the General Data Protection Regulation. If one is using the AI system in the course of a personal and non-professional activity, and what's important, there's no exception for research. So even if you're conducting research in the European Union, you're provider or deployer of this AI system. It's a very wide territorial and personal scope of application, and the exception for deployers is similar to the exception from the GDPR, which says that this regulation does not apply to the processing of personal data by a natural person in the course of a purely personal or household activity. And it's the same for the AI system. So if you're using like ChatGPT 3, then the AI Act won't affect you if you're a deployer and it's for the personal use. Then there are some exceptions of the scope of application. Article 2, paragraph 2 of the AI Act refers to Annex 1, Section B, where some sectors are excluded from the scope of application. You may find some laws about motor vehicles, like the Motor Vehicles and Trailers Regulation. It's very famous, Regulation 2018/858, so-called type approval or European type approval law, or the Regulation 2019/2144, with all the driving assistance systems to get a type approval. And then other sectors like aviation, rail transport, maritime transport are excluded. And AI for military purposes is excluded, as well as when authorities in third countries or international organizations in the context of law enforcement and judicial cooperation within the EU use some AI systems. These fall outside the scope of the AI Act. When you think of these sectors, you can ask yourself if there are some similarities which make it logic to exclude these sectors from the scope of application. And if you have a deep dive into these regulations, you find out that these are very high regulated sectors. They have like a so-called market access law, like speaking for cars. You can't just buy a car and drive it. At the very first, at the beginning, the manufacturer has to get a type approval in order to put the cars on the market and to sell the cars. And all these sectors have a very detailed market surveillance. So after putting the products on the market, you have to look out for risks, for damages, and something like this. So that's some similarities of all these sectors which are excluded from the AI Act. If you now think as an automotive manufacturer, you don't have to look for the requirements of the AI Act. That's not the case, because recital 49 of the draft says, with regard to high-risk AI systems that are safety components of a product or system itself falling within the scope of application, it is appropriate to amend these acts so that the Commission takes into account the mandatory requirements for high-risk AI systems when adopting any future delegated or implementing acts. So the forthcoming AI regulation will not apply directly to autonomous driving, but the requirements for high-risk AI systems will be adopted and introduced in the respective sectors, for example, the type approval law. So requirements exist despite exception from the scope of application. When thinking about the scope of application and the regulation, you have to define what AI is to regulate AI. And there's no unified definition of AI in the legal sciences. And there's also no common definition across different disciplines. There's a general distinction made between weak and strong AI, especially in philosophy and in technical disciplines. But there is no standard definition of these categories. And the boundaries between strong and weak AI are very fluid. So it's more like a phenomenological view than a sharp definition. And you would, for example, say the toothbrushes are a weak AI and an autonomous vehicle would be a strong AI. But that's like the disadvantage of this system to difference between strong and weak AI, that it's not a clear definition. That's why this definition isn't suitable for any legal evaluation and not suitable for the regularization of AI. That's why the European Commission came up with an own AI definition proposal in Article 3, number 1, where it said AI systems means a software that is developed with one or more of the techniques and approaches listed in Annex 1 and can, for a given set of human-defined objectives, generate outputs such as content, predictions, recommendations, or decisions influencing the environment they interact with. And Annex 1 shows and lists a lot of techniques and approaches. There you have, for example, machine learning approaches, where any developer will tell you, yeah, that's something we connect with AI. But you have also other techniques like logic and knowledge-based approaches or statistical approaches, where a lot of technicians say that's not AI at all. So it's a very broad definition with several undefined legal terms, which also cover, it's even written in the definition, software. Because at the very beginning it says AI system means software. So this is a very broad definition which covers also normal software. This definition was criticized a lot in the legal debate or legal discourses because it's a very broad definition, and the distinction from the traditional software is very hard and perhaps not even possible. And it's unclear what level of influence is required to be called an AI system under the AI Act. This definition is very unsuitable for analyzing the legal impact of the AI system because the previous attributes of an AI, which were debated in the last 5 to 10 years, weren't taken into account. This would be the autonomy of an AI system, the opacity of an AI system, the complexity, and the multi-causality. And complexity, for example, means that you don't know when and why a damage will occur in a very complex IoT structure. So this very broad and imprecise definition leads to legal uncertainty. And now in the second reading this year in April, the European Parliament had voted on a different definition. It says AI systems means a machine-based system that is designed to operate with varying degrees of autonomy, that once operational can be adaptive and that derives from outputs received for explicit or implicit goals, how to produce outputs such as predictions, content, recommendations, or decisions that can affect physical or virtual environments. So even virtual environments like the metaverse are covered by this definition. And you may see Annex 1 is deleted, or the former Annex 1, and the definition they voted for is more narrow now. And when we think of policy options to regulate AI, now we have seen the scope of application, we have seen the AI definition, so the scope of the AI Act. There are some regulatory options. You could first of all prohibit using AI in the European Union at whole. You can, on the contrary, regulate any AI being used. You could say, oh, we don't regulate AI at all. Or you could say you're going to regulate AI depending on the risk which comes from each AI system. And that's what the European Union does. The AI Act has a risk-based approach and therefore has different types of AI systems. First of all, there are some AI practices which have a very high risk, which is so high that they are prohibited. So Article 5 lists prohibited AI practices. Then the main part of the AI Act is all about high-risk AI systems, which are definitioned in Article 6. And then you have so-called low-risk AI systems. There you have some transparency and information obligations, like for chatbots. And then at the end, you have minimal risk AI systems. And there you don't have any requirements at all. And when you think back in 2021, the draft of the AI Act was published by the Commission. I think it was in April. No one back then knew things like large language models like ChatGPT or like Llama and so on. And in the legislature process, they now amended the draft and put in so-called general purpose AI, which isn't a defined AI system because, for example, ChatGPT, you can use it to write poems, to write songs. But on the other hand, you could use it in a company to decide which applicants for a job will be taken. So therefore, the general purpose AI can be high risk, low risk, or minimal risk AI systems. Coming to the different types of AI systems. First of all, you have the prohibited practices in Article 5. And there are several practices listed, like underlying influence outside of a person's consciousness, or exploiting vulnerability vulnerability, so-called social scoring by authorities, like it's known from China. And it's forbidden to real-time biometric remote identify people, like, from some Hollywood movies, for example. But what is very interesting, research is allowed on all these prohibited practices. So you can conduct research on biometric remote identification, but you're not allowed to deploy such an AI system on the market or to use it. Then you have the high-risk AI systems in Article 6, and they can be a safety component or a product themselves from Annex 2. And they have to have a third-party conformity assessment. And Annex 2 lists the regulation 2018/858, the European Type Approval Law, and products covered by it for high-risk AI systems. So even if the AI Act isn't applicable directly to autonomous vehicles or other vehicles, it says that every vehicle or every product falling under the scope of the regulation 2018/858 is a high-risk AI system. So every future autonomous vehicle will be a high-risk AI system, which is very hard because you don't know each risk of these systems. And there are other high-risk AI systems, which are listed in Annex 3. And there you can find lots of systems, not from like harmonized markets, but it's more listed from like everyday life parts, like working place and so on. So every AI system used at the workplace is therefore called an high-risk AI system under Annex 3. Then you have low-risk AI systems like chatbots and deepfakes. And low-risk AI systems are AI systems which are intended for interaction with natural persons. And there you have just transparency and information obligations, like regarding the existence of human supervision and accountability of the decision-making process. And coming to AI systems with minimal risk, with no requirements at all, but you're free to establish a code of conduct and to fulfill on your own wish the requirements of an high-risk AI system within this code of conduct. In the AI Act proposal, there are a lot of requirements for high-risk AI systems in Chapter 2. And first of all, you have to have a risk management system in Article 9. You have to establish such a system, and it shall cover the development and construction period of the AI system, as well as its entire life cycle. You have to have a regular systematic updating, and findings from the manufacturer's product monitoring pursuant to Article 61 are also to be integrated into the process. And there's lots of requirements speaking about data and data governance, which focuses on the quality criteria regarding training, validation, and test data sets. And this is to prevent biases in the data sets and hence discrimination. Training, validation, and test data sets must therefore be relevant, representative, error-free, and complete. But if you speak with developers, the data set is never error-free and never complete. This was criticized huge in the last 3 years. And that's why for the first reading, the European Parliament brought up a new definition and a new requirement and said training, validation, and testing data sets shall be relevant, sufficiently representative, and to the best extent possible free of errors and complete in view of the intended purpose. They shall have the appropriate statistical properties, including, where applicable, as regards the persons or groups of persons in relationship to whom the high-risk AI system is intended to be used. And these characteristics of the data sets may be met at the level of individual data sets or a combination thereof. But if you are now asking yourself, what is to the best extent possible, free of errors and complete in the view of the intended purpose, there's a broad range what to the best extent could mean when an authority tries to sue or to sanction with a fine a manufacturer, and manufacturers will say, oh, we have these kind of data sets, and for us, that's already the best extent possible, speaking about free of errors and what is sufficiently representative. So there are a lot of legal uncertainties and a lot of undefined legal terms in this requirement as well. But they avoided to say, like in this previous version, that it shall be relevant, representative, and error-free as well as complete, but instead adding sufficiently represented and to the best extent possible. But now that brings legal uncertainty up. Then you have a technical documentation in Article 11, and you have to prepare a technical documentation by the manufacturer before the AI system is placed on the market or put into operation. This documentation should show compliance with the requirements of the AI Act, and national authorities as well as notified bodies can have a look inside these documentations. And there are a lot of requirements concerning the documentation in Annex 4. When AI systems shall be built, that they are keeping records, the manufacturers must design the system in such a way that it's recording the operations and that there's a so-called event recorder. Therefore, a logging must comply with recognized standards. And the goal of this requirement is the verifiability and traceability of the AI system, which enables the manufacturer to monitor the operation of the high-risk AI systems. And this shall allow the manufacturer to detect risks of his product. Then there are some transparency and information obligations, like you might know from the General Data Protection Regulation. And that's due to so-called black box algorithms, which leads to opacity. So these decisions are not transparent, and users, therefore, of these high-risk AI systems shall be extensively informed, and instructions for the use must contain precise, correct, clear, and as complete as possible information for the user. And they are intended to enable self-responsible handling of risks so that the users are able to use the high-risk AI system and to interpret the outputs having biases or something else in mind. you saw that the AI Act will have a lot of requirements for manufacturers, but until now there was no enforcement and no sanctions. But as well as other regulations, such as the GDPR, the AI Act will have a huge enforcement and sanction program in Article 99. If there's an infringement of Article 5, a fine up to 35 million euros, or in the case of companies, of up to 7% of the annual worldwide turnover is possible. Regarding infringements of remaining requirements of the AI Act, it's, you could say, only 15 millions, or in the case of companies, up to 3% of the worldwide annual turnover. And for false, incomplete, or misleading information provided to notified bodies and competent authorities in response to their request for information, it's 7.5 million euros, or in the case of companies, up to 1% of the worldwide annual turnover. There's no entitlement to compensation for damages on the part of affected individuals, and there's no liability regulation inside the AI Act. So if there's like an accident with an AI system, you can't sue the manufacturer directly with the AI Act. Coming to the conclusion, it's the first fully harmonized legal framework for AI in the European Union and as well in the whole world. It will be very interesting what the impact on other countries will be. It's the so-called Brussels effect. And on the other hand, there's a huge considerable legal uncertainty due to numerous undefined legal terms, like in the AI definition or in other articles and requirements. And there's the very broad definition of AI, so that you can say it's more like a software regulation than an AI regulation. The impact is far greater for companies than the impact of the GDPR, because there are so many requirements and there are many approaches to minimize the risks of AI. So having in mind to regulate the technology and to deal with risks. There are several approaches like prohibiting some AI practices. But all in all, it's no successful regulation of technology with a major impact on the economy and mobility of the future because of all these undefined legal terms, which lead to great legal uncertainty. Thank you.
Thank you very much for your lesson, which was extremely interesting and rich of many things to discuss. In fact, I did know this because I heard you in September last year, and I expect like a lesson like that. So it's extremely interesting. I will leave first of all the floor to the students, and so to the question and curiosity coming out from your lesson. But I also have something to ask you. But before my question, I will leave the floor to them if they have a question or curiosity on this aspect you have discussed about. Is anybody? So perhaps I will start with one thing. The first question is this is very interesting. The idea you have outlined, the idea of a sort of continuous dialogue between law and science, when you see that we have a sort of need of technological compliant design. So this is very interesting because all the course is based on the idea of a interdisciplinary dialogue between many different approaches, but in particular, the approach of the engineer, so what is possible to do on the one hand, and on the other hand, the problem to deal with the law, because the law sometimes is in some ways misleading or sometimes hamper the progress. And so the first question is, how productive is the dialogue between law and engineering, and how do you think it will improve in the next years, especially in a perspective of global harmonization, in which the technique will be the leverage to make harmonized all the laws in the European Union, but also in a wider environment?
That's a very good and interesting question, because I think when I had the first look on the AI Act proposal of the European Commission, and when I discussed the requirements with developers, they said, the people from the Commission, the lawmakers, the lawyers in the Commission, don't know anything about technology and AI, and they told me, like, we can't fulfill these requirements and these requirements can't be fulfilled. And I thought, yeah, that makes sense. And when I read the AI Act further on, I thought, there are very strong requirements for the technology, and there are very, very lots of legal undefined terms where I, as a lawyer, don't know what would be enough to fulfill these requirements from a technical point of view. So I think very often the politicians and the lawmakers have a real gap between the knowledge which technology which circumstances occur and how to deal with them. And so I think this is a real problem to face. So we will have to see if the upcoming AI Act will affect other countries outside the EU. But I think the problem that on the one side you have the law, and on the other hand you have the technology, and perhaps lawmakers and lawyers don't speak enough with the technicians, so they don't know every time how to best regulate the technology.
Yes, this I think is very, very interesting. And also another question, very interesting, which I have analyzed before while you were speaking, is the problem of the teleguide, so the remote driving, because in this case we do have an idea of driver which is inside the car, and this is an idea which is common in every European state. And so my question is, what if we in the future will develop enterprises in which we have, for example, teledriver located in Italy, but which operate cars which drive outside the Italy as well? For example, imagine a journey from Bologna to Munich, for example. And so when I pass the border and I continue with an Italian located driver remoted, but the car goes in another system. So this is interesting because I think that we need to reconceive our traditional approach, but to do it in an harmonized way. What do you think about this?
It's a very concrete problem in the even for manufacturers, because inside the European Union there's even no harmonized behavioral law. So when I'm programming the driving functions, I have to check for every 20, I think, 8 member states what's the behavioral law. And speaking about teleoperated driving, it's the same. So you have to know, first of all, how to behave in each and every country, and it can differ. And perhaps some countries have law about teleoperated driving, some not. Then you have to think, is it possible to deploy a system if they don't have a law? And then you have the legal different frameworks of liability law, where you have sometimes owner or keeper liabilities, sometimes just driver liabilities. And I think that makes it really complex and hard. And in the last month, I discussed a similar point with a professor from the US, which is working on the development of automated driving functions there. And they told me they have a problem because in the US, they don't know the keeper liability. So they have the driver liability and the manufacturer liability. And they have the fear that with increasing autonomy, they have a lot of manufacturer processes, claims, where people sue after an accident the manufacturer of a car with lots of costs, but no driver liability, and they don't know our keeper's liability or owner liability. So speaking of different markets, there are like really different legal systems and really different problems, because I said in Germany, that's no problem, because if there's no driver in the car, because it's an autonomous vehicle, you can sue the keeper of the car, is insurance company. And as a private person, sure, you don't have to have a very expensive claim against the car manufacturer. And he said, oh, we don't have this. And I said, okay. And I think that's very problematic, because speaking about like traffic law, even in the union, you have no harmonized behavioral law. You have different laws which allow or prohibit the automation. And I think that's something which will be needed to have more harmonized laws on this topic. Anna, you're muted.
Yes, I completely agree. And just give you another very quick question coming from the audience, but for simplifying, I give it to you. The question is more general. It's about the new scenario of automation, but also seen in the perspective of the so-called weaker users of the road, which are on some ways there is a paradox, because at present they are protected by the laws on the traffic rules laws, but on the other hand, they are not put in the best position to exploit this protection, because they suffer a sort of knowledge gap. So, for example, imagine a little baby or a teenager walking around or cycling around is protected by the laws, but on the other hand, is not put by the system in the best position to know very well and exploit these laws, because nobody is completely worried about the effective knowledge of this. So what can do the system in order to increase this knowledge, and also what can do the system in a perspective of a new mobility in which everything is automated, by these users of the roads perhaps continue to suffer a sort of marginalization, because they are into the traffic, but they are not trained, educated, etc., etc.
It's a very good question, and I have no real answer how you can do it in a really good way. So in Germany, in the Road Traffic Act amendment in 2021, there's a requirement that driving functions are not allowed to differ on the basis of different like attributes of people, like on gender, age, and so on. So there's in our Road Traffic Act the prohibition to distinguish people and to act due to these circumstances. So you couldn't, in some cases, you weren't allowed to say, oh, it's a teenager or it's an elderly people. So you have to like just say, oh, the car detects an object and that's moving, that's a human being, or that's in like another car. You can do this, but the communication and information obligations of the car to show like it's automated or it's driving in autonomous mode, this is something which is really complicated, and I think it needs like awareness in the society or big discussion with manufacturers, with politicians to bring awareness to the society that a new type of mobility is increasing and coming up, to have a debate on how to deal with risks, how to define what kind of safe is safe enough to be operated in the roads and so on.
Thank you very much. I think, I don't know if there are any other doubts or curiosity in the class. Otherwise, if everything is clear, we are now close to the end of the lesson in Italy. And so this is perhaps one of the last lessons of the year, but we are extremely grateful for this because it is extremely rich of many things to develop for the future edition of this cycle of seminar. And so we thank you very much. I give you the view of the class, which enjoyed your lesson and which appreciate so much your lesson, and we hope that we can have you in person in Bologna in the next edition of this seminar, and we can see each other as we did in September in Naples. So thank you very much for your precious contribution, and I hope we can have you here with us in Bologna very soon, perhaps when we start again the lesson the next academic year.
Thank you very much for being here, and yeah, it would be very great to see you in Bologna in the next year, and thank you very much for the invitation.
Thank you.